termination of approximately 26,000 college teachers who are working like as a part-time teacher, as a guest teachers, as a contractual teachers. Termination has been sought by an association. So an association is asking by filing a writ petition before your lordship, all the persons who have been serving for last about 15 years, 20 years, 26 years without naming anything, their service should be terminated. If anyone says anything about it, just a little bird's eye view. This is a matter before your lordships where termination of approximately 26,000 college teachers who are working like as a part-time teacher, as a guest teachers, as a contractual teachers, their termination has been sought by an association. So an association is asking by filing a writ petition before your lordship that all the persons who have been serving for last about 15 years, 20 years, 26 years without naming anything, their service should be terminated. On the very first day, one such associations for whom I am appearing, our member is approximately 2,000. We made an applications making a prayer that it will have a devastating effect on us. That was allowed. We are made as one of the parties, and the Honorable Justice Tapurbrata Chakraborty specifically recorded the maintainability of the writ petitions that is kept open, and no interim order was granted. They challenged the fact of refusal before the Honorable Division Bench. Matter was kept pending for a long time. Now this has been sent back with a request to expeditiously hear out the matter. I have one humble prayer. I have seen there are large number of petitioners, respondents, UGC, etc. And this kind of matter most likely not going to be end here, because I don't want to use the word political, but it has an implications. When someone asking for a termination of 26,000, he might go up also. All I pray today, I have filed my oppositions, I have served to the writ petitioner, but he has not filed his reply. UGC and others might be there also. All I'm praying, let the pleadings, whoever has done, that be exchanged. But I may have a good case, but I don't want to win on a small point, because tomorrow I may lose before the division bench by saying that this point was not taken by your lordship. That point. So today, all I pray, I think all of my learned friends, they would agree with me that all the pleadings may be exchanged among ourselves. Lordship may keep a matter on a particular date, and then lordship hear of them.
That would be
the matter was made for order sack second. We should be clear. Should be granted liberty to approach the single bench or any, because our appointment is not to be cancelled, my lord. We are not made party. I have taken on an application for it.
My lord,
this application allowed.
last time I pointed out, they filed an application. They were absent last time. I pointed out.
I think since the division bench granted the liberty, it is an indication that they should be added. So
let them be added. My lord, what happened?
My lord, my learned friend and my learned senior were not there on the earlier occasion. What happened, Mr. Panda also, my lord, placed before your lordship a judgment of the division bench where, my lord, this notification stands. Mr. Panda had, my lord, submitted before your lordship, and your lordship wanted to know whether this particular notification that is under challenge in this writ petition were assailed before the division bench or not. My lord, we are carrying the public interest litigation. My lord, this was assailed, and the, my lord, division bench even in the review, my lord, said that the UGC notification or the UGC guideline on the basis of which the notification has been challenged, my lord, has no statutory binding effect. Your lordship has the order. Your lordship kept this matter for orders only for the reason that your lordship wanted to be satisfied whether the notification that has been challenged in the writ petition was challenged in the public interest litigation.
May I be permitted?
My lord, that
I am the
has been
petitioner, my lord.
We have the,
My lord, I am the petitioner. May I be permitted to make my
submission? Has the hard copy of the PIL. I have the
one by one.
My lord, I am the petitioner
of the division bench judgment. My lord, lordship kindly.
My lord, kindly cease the prayer.
Oh, okay, today, let the application for addition of party be allowed, and I am fixing on one date. Then,
And in the meantime, all pleadings may be
all
exchanged.
pleading may be exchanged, and then the court will apply its judicial mind. That would be better. And don't start shouting.
That would be the appropriate. This judgment in my
review also dismissed, my lord. Review also dismissed.
My lord, I will satisfy you. I will satisfy my lord on that point.
My lord, on the self,
I will satisfy my lord on that.
What is your application? Can 4. So none are opposed.
No.
Can 4.
No, I'm not opposing Can 4, but
Hey,
it must be on representative, my lord, representative capacity, my lord, because it will never end, my lord. It will never come to an end. Because what is happening every day, my lord, a batch of persons are coming with an application.
Can 4 filed by whom?
They are the only person whose service has been approved by the DPR way back in 2010. Now in 2030, they have been charged. A regular selection process with an export of Calgary University. Now they have been approved in 2010. They are termed as contract for full-time teachers.
Effectively,
Can 4 of 2025. This is an application for addition of party.
Lord, UGC is one of the respondents. UGC is one of the respondents.
Okay, you serve a copy. It would be served. This is an application.
that will only come when Lordship is satisfied they have got a locus. The first order by the Honorable Justice Tapobroto Chakraborty specific recording was maintainability of the writ petition is kept open. So on the next date, first Lordship kindly hear us. We'll assail that he doesn't have a locus because he was not one of the participants in the competitions. He is nobody. He is an association. This is not a public interest litigation before Lordships. Once he succeeds, only thereafter merit and others, and then paper publication, everything may happen. Prior to that, as Lordship is
Maintainability point is to be determined.
yes,
First.
that be determined
But my lord,
whether he has a locus or not.
In this
If
regard,
he doesn't have a locus, why your Lordship would be wasting time? And when there is an order recorded by the coordinate bench sitting singly, there is a specific order that maintainability kept open. So it is not that Lordship will hear out the matter for 7 days and thereafter decide that no, it is not maintainable. It will be wasting of the judicious time of the court. So Lordship may fix a matter on any date that suits your Lordship.
Okay.
But my lord,
But
my lord, the justice, the order of the honorable division bench presided over by Lord Justice Tapobroto Chakraborty merged into the order passed by the division bench presided over by Justice Horace Tandon. That merged, and that order, that is the latest order of the honorable division bench. Nowhere it is mentioned the maintainability should be kept.
No. That's I will address. Maintainability is kept
Nowhere
open.
it is mentioned.
No.
In the very
The
first
order of
itself of this
the order of Justice Tapobroto Chakraborty has not been modified. Only the division bench has remanded with a request to expeditiously hear
Division
the
bench
matter.
has recorded, honorable division bench has recorded the entire facts of this case, my lord.
Lordship will
in
hear out
nutshell.
when Lordship actually takes up the matter, not in this shortcut method. Lordship may kindly see the order dated 24th of February 2020. Direction and word.
10th January 2025.
Yes, my lord.
Yes.
My lord, can you see
Since the
that?
appeal is against refusal to pass an interim order.
Yes.
My lord.
Way back in the year 2022.
Correct.
We do not
No,
think
2020.
interference.
We do not think that interference in the instant appeal is warranted. Kindly mark this. So no interference means existence of Justice
If
Tapobroto.
the petition itself decided on merit.
Yes, correct.
Merit.
Correct. But this merit.
So not on
this
maintainability, my
is
lord.
a
On merit.
contextual merit. It does. This merit
Not on
doesn't.
maintainability.
No.
On merit.
No, I will argue. I think this is too small thing to argue on that. This is not a decision by the Honorable Division Bench to the effect that the order of the Honorable Justice Tapobroto Chakraborty recording that maintainability kept open, that is completely diluted. No. Had it been so, then this word, we do not think that interference in the instant appeal. The merit includes, I am not saying the High Court doesn't have jurisdiction. I am saying the petitioners, locus is a part of the merit itself.
But point of maintainability as urged by Mr. Dhor,
Yes.
learned senior advocate appealing for the applicants in CAN 1047 of 2020 is kept open to be decided at the time of final hearing of
Exactly. That is my prayer. And that remains.
Final hearing of the appeal.
Yes.
That means it would be decided at the time of final hearing.
Absolutely right. Correct. Now,
That
if-
means one of the issue would be whether
Yes.
this petition is maintainable or not.
absolutely one of the issues,
Although this issue is to be decided first.
exactly the order.
If this issue is decided, then no, in the fashion that no, the petition is not
Absolutely.
maintainable.
The order.
Order.
The order of the issues would be number one. is
Number
this.
one, number.
Yes.
Then there would be
Yes.
no requirement to go
Exactly.
into the other issue.
Correct. Otherwise, my lord,
Okay, so I am on consent. I am allowing the addition of party without.
My lord, I have a humble request before your lord.
Why you are preventing the court?
No, my lord. I have.
What is your request?
Some permission. Yes, my lord.
I do not know who is he, my lord.
My lord, in the division bench, I appear before the division bench on can 4162, but of 2020, my lord. But that can has not been attached with
Can filed in connection with mandamus appeal.
He
Why
must
it
be
will
sitting in the
come
same
in the
boat.
writ petition?
my lord.
So, my lord, can you seize the problem?
Yes, my
One
lord.
person will come,
I
get him
think that-
added, and
that-
again this will go on.
The application has already been filed. This application liberty was granted by the division bench to consider, and hence this court is considered. The order which will be passed, it may affect many persons. That not means that every day they will come
My lord,
and
my-
court will go on passing an order for addition of
My
party.
lord, that can
Okay.
that can maybe be added with attached with this.
And I think if this order passed in this petition, if adversely affect anyone, he can prefer appeal with a with an application seeking leave before the division bench. That I have been affected.
Then my lord,
But if the court go on adding one by one,
No,
carriage of proceedings will be stopped.
Because now we would
No,
be
my lord.
sailing in the same boat.
Yes.
Ultimately, Lordship would be hearing locus and the other points.
And
would
the
be
other
hearing
points
if
to be
required.
raised.
So if we succeed, I think that means all of us succeed, minus
Yes.
the writ petitioner.
Yes.
my lord,
Okay, আসুন আচ্ছা
The only
My lord,
humble
if-
আচ্ছা কি allow the court to pass the order. হ্যাঁ কি বললাম? Injunction against filing a suit.
One humble prayer, my lord. One humble prayer, my lord. My lord, kindly records our submission because it will be a repetition, my lord, in view of the division bench judgment passed in my lord.
Okay.
My lord,
This
this
issue will be addressed. Don't worry, this issue will be addressed. Let the exchange of pleadings
This-
be completed.
need not to be dragged, my lord, just by placing.
Okay,
a
on
petition.
that date it would be considered.
I'm
Don't all the issue which should be raised by you
I am
will
not, my lord,
adequately dealt with.
Grateful, my
my
lord.
lord, since I am not challenging the service of any particular candidate, I am only challenging a notification.
No, your
So in that case, my lord,
notification will affect
that
all of us.
notification may
Division
adversely
bench,
affect
my
the
lord,
others.
division
Okay,
bench already
on
applied the
that
notification.
date you will place your case. You are the writ petition.
My lord.
That notification
That day.
and it has been submitted. Submission has been advanced on behalf of the other parties to this proceeding. That this notification was also challenged in a
That I will satisfy, my lord.
in
I
a
will
public
satisfy.
inter litigation. However, and the notification was issued based on a notification issued by the UGC.
UGC.
Now the division bench in a public inter litigation has decided that such notification of the UGC has no statutory force.
My lord.
No, my lord, no. I
Thereafter,
join the issue, my
the
lord.
notification,
Totally misleading, my lord.
okay,
Totally misleading.
on that date, preserve your energy. Preserve your energy for the day.
Copy should be served within
Eh,
a week. My lord.
Serve.
Hey.
I am not passing any order. You serve.
By today.
Yes. By
স্যার আমাদের
course.
কষ্ট দেখেছিলেন তো স্যার
My lord.
ওকে আর গুপ্তাজির নামটা বড় করে লিখে দেবেন বললে
Otherwise,
Public.
again I have.
ওকে
So this
my lord has fixed on my lord